Muslim personal law permits the marriage of girls under the age of 18. Customary law, recognized in India under the Shariat Application Act 1937, permits, legally speaking, such marriages. A Muslim girl, upon attaining puberty, can be married off. Such practices survive in modern-day India despite a law like Prevention of Children from Sexual Offences Act 2012. And these customary practices get the legal sanctity under the pretext of personal laws. Why do such archaic laws continue to survive despite equality being a fundamental right of each and every citizen in this country? Hello and welcome to this edition of Let's Talk Law. I'm Anusha Soni. Today we talk about the customary sanction recognized in law to the marriage of underage Muslim girls, an issue which is currently pending before the Supreme Court of India. Any person below the age of 18 is recognized as a child under the provision of POCSO. Indulging in sexual activities with a child is a sexual assault. The Supreme Court, in its landmark judgment of 2017, struck down Exception 2 under Section 375 of the Indian Penal Code that gave immunity to the husbands of minors who indulged in sexual activity with a minor wife from being prosecuted for rape. Sex with a minor wife is rape, according to the Supreme Court of India. The direction of evolution of law, deduced through various judgments, is absolutely clear. The judiciary wants to do away with such regressive practices. Despite a clear intent from the judiciary and also the parliament, the Muslim personal law, which is uncodified largely, allows the marriage of a Muslim girl upon attaining puberty, even if she is below 18 years of age. The practice is yet to be outlawed by the courts or the parliament of the country. Religious reforms are often marred by the politics of opportunism and driven by the need to appease the conservative within the fold. Well, take the case of Hindu personal law. Steering reform in Hindu personal law was no easy task. In fact, translating the Hindu Code Bill into a reality was politically very difficult. The architect of the Indian Constitution, Dr. Bhim Rao Ambedkar, was the earliest proponent of women's rights and religious reform. Dr. Ambedkar resigned as the law minister from Nehru's cabinet when the government did not pursue the Hindu Code Bill with the requisite political vigor. The strides made by Hindu women in all spheres of life and the fierce assertion of their identity would be impossible without the reform in the sphere of personal laws. But the story of Muslim personal law is one ridden with appeasement and an utter lack of courage from the political class. The case in point is the historic subversion of the Shah Bano judgment by the Congress government led by Rajiv Gandhi in 1986. The Supreme Court granted right of maintenance to Muslim women beyond the period of 3 months or iddat at par with Hindu women. In response, the government diluted the judgment by bringing in a special legislation that in some way did away with the Supreme Court's reform measure. Now, this move consolidated the marginalization of the progressive voices within the community and mainstreamed the regressive ones in many ways. One of the most troublesome aspects of the Muslim personal law is the fact that it allows the marriage of underage girls, as I said earlier. The customary practice stands in stark contrast to India's jurisprudence and how Constitution has been interpreted to give equal rights to women in social, religious and public sphere. While the reform of any personal law, especially pertaining to minority, is a tricky and difficult task in any country. Reform requires codification of personal laws and practices. Hindu practices of saptapadi or marriage, inheritance, adoption were all codified, and only then over the years they could be reformed. For example, polygamy could be outlawed in Hindu religion through codification. It's true for most other religions and faiths in the country, but the Muslim personal law remains largely uncodified. There is no codification of the process of marriage, divorce or adoption under a statute. The process of codification is patchy. For example, Muslim Women Protection on Divorce Act 1986, brought with the intent of nullifying the Supreme Court judgment, limited the period of getting maintenance, which was later corrected by the Supreme Court's eventual intervention. Or the Dissolution of Muslim Marriages Act that lists down the grounds under which women can get khula or divorce and maintenance. But the process of marriage and divorce is governed by customary practices which are largely uncodified, without any legislation. Now, the Supreme Court gave its judgment on triple talaq. It was a huge milestone and yet another precedent of Indian judiciary's commitment to the right of equality for the women folk. But I dare say the judgment is another piecemeal approach. The court ruled on the constitutionality of a particular practice, triple talaq or talaq-e-biddat, but did not overrule Narsu Appa Mali, another crucial judgment. The judgment, or rather the ghost of Narsu Appa Mali, prevents the personal laws from being tested against fundamental rights. Though triple talaq is a criminal offence, we still don't have a thorough codification of the Muslim personal law pertaining to marriage and divorce. This particular gap has led to archaic, regressive practices like marriage of minor Muslim girls to survive in India after 75 years of independence. A common civil code or a uniform civil code will only be a reality once the process of codification is undertaken, especially for the Muslim personal law. A staggered reformist move through a judgment or a law shall only be the first aid to the wound and not the impending cure. Muslim personal law should be codified, and the so-called marriage of Muslim girls under the age of 18 should be outlawed. The matter right now is pending final adjudication from none other than the Supreme Court of India after conflicting judgments from the High Courts. Let's see what the Apex Court decides in this matter. Thanks for watching.